Hi everyone, and welcome to this Mathys Squire webinar. My name is Saba Ismail, BD exec at the firm, and I'm delighted to be your host for today. This webinar will focus on intermediate generalization at the European Patent Office, which will be presented by Michael Stott and Posy Drywood, both European patent attorneys at Mathys Squire and a part of the life sciences and chemistry team. I'll just do quick introductions and then hand over to the speakers to dive into the session. Posy has expertise in drafting and prosecuting patent applications, as well as managing global portfolios. As part of the chemistry group, Posy is particularly familiar with inventions in the fields of pharmaceuticals, oil and gas, batteries, and green technology. Our second speaker is Mike, who has significant experience of opposition and appeal proceedings before the European Patent Office. He has got wide experience in a range of technologies in the chemistry field, including pharmaceuticals, polymers, electronic materials, and food chemistry. Both Mike and Posy work with a range of clients from multinational companies to SMEs and universities. So without further ado, I'll hand over to Mike.
Thanks for that, Saba. Okay, so as Saba mentioned, today's webinar is on the subject of intermediate generalization at the EPO. I'd be the first to concede that this isn't the sexiest of subjects to be talking about today, but it's nonetheless an important issue that can be a real thorn in the side of applicants and also very problematic in post-grant proceedings at the EPO. So we hope that today's webinar will at least be informative and offer some practical guidance. So firstly, we'll look at an overview of intermediate generalization, just to refamiliarize those people dialed in. Then move on to a look at the case law and some of the developments that have been coming out of the technical boards of appeal at the EPO. And then compile something of an arguments checklist, a list of considerations that can be given when faced with an objection over intermediate generalization and what you might look to do depending on the particular circumstances in your scenario. Then look to an example where we'll walk you through how some of the arguments that we've discussed could be applied in practice. A word of caution on a couple of points, and then some drafting tips before we finish with some questions. So starting then with a definition of what we're talking about today, intermediate generalization, and this is hopefully familiar to many of you, and it's the definition in the guidelines. So the extraction of a specific feature in isolation from an originally disclosed combination of features and using it to delimit claimed subject matter. And on that basis, it falls into the category of added matter, and therefore can contravene Article 1232 EPC on the basis that it would impermissibly extend beyond the content of the original disclosure. I think it's important from the outset to stress that intermediate generalizations can be allowable. So if you do see intermediate generalization in an office action from an EPO examiner, it doesn't automatically mean that the amendment is unallowable, although there are criteria set out in the guidelines that an intermediate generalization should satisfy in order to be allowable. And those are set out here in this slide, where we have no structural or functional relationship between the feature extracted from the embodiment and the remaining features, or otherwise an inextricable link, and also the requirement that there's an overall justification for the generalization within the original disclosure. In terms of a clear distinction between structurally and functionally related and inextricable link, there isn't so much clarity on that point in the case law that we've seen. It seems that in actual fact the The term inextricable link perhaps applies more in chemical cases where you might have, for instance, several components of a composition where ascribing some sort of functional or structural relationship might be difficult, but nonetheless, it means that the examiner's reach in terms of the purview of the objection, at least, can extend to those types of situations as well. So in some senses, this inextricable link just gives the examiner an extra tool in which to raise an objection. If we look just to the case where we're permissible, it seems that the skilled person should, without any doubt, conclude that the characteristics that are taken from a detailed embodiment are not closely related to the other characteristics of that embodiment and can be applied directly and unambiguously to the more general context. So at this point, we now have this functional and structural relationship that can't exist, and we also are told that there can be no inextricable link, and that also now here that there should be no closely related characteristics between the features of the embodiment. So it feels almost quite an uphill struggle from the outset. But fortunately, there's case law that help understand these requirements and offer some possibilities in terms of arguments to overcome these types of objections, and now that's what we're going to focus on. So this slide really is highlighted just to let you know really what is likely to be unhelpful in terms of arguing intermediate generalization at the EPO. T1238/08 here clarifies that really the style or the format of the application can't be used as an excuse for why there isn't explicit fallback positions set out in the disclosure. So this will be, of course, familiar to attorneys that are used to US style drafting, where perhaps there's a focus on a specific embodiment or a figure, and the invention is defined with a close focus on that narrower embodiment, with perhaps an indication elsewhere in the disclosure regarding how you could extrapolate from that position, but not necessarily with the support for the intermediate position, if you like. And so the EPO don't see it really as an excuse or really give any sort of wiggle room on the basis of where your application originates and the style of drafting that's been adopted, unfortunately. Another point I thought worth highlighting for a couple of reasons, and this is touched upon in T2311 of 10 and T2489 of 13. Really, it relates to the kind of arguments that you have at your disposal in attempting to overcome intermediate generalization. Here, they clarify that the 3-point essentiality test, which is a test that sets out the requirements for an allowable amendment in the case of a deletion from a claim. That makes clear that the requirements there aren't considered helpful for assessing whether an intermediate generalization is allowable. Really, the point to be made here is that objections over intermediate generalization need to be responded with case law typically dealing with intermediate generalization specifically. Those on the call that are more familiar with the essentiality test will recall that that sets out a requirement that the deleted feature is not explained as being essential to the disclosure, and secondly, that it's not indispensable for the function of the invention in light of the technical problem it's purported to solve in the disclosure, and that there's no real modification required of the other features in order to compensate for the loss of that feature following deletion. And although these decisions clarify that this essentiality test isn't relevant, it's actually quite interesting that some later decisions that we'll look at still seem to touch upon a few of these points, although not simultaneously. And really, the decisions we'll focus on now encourage a wider assessment of the disclosure, which is useful beyond really the literal disclosure of this specific embodiment, and they really teach the assessment of the technical problem underlying the invention, which can be useful in order to broaden out the examiner's assessment of the basis. So we'll move on to those in a moment. So these cases are fairly old now, as you'll see, T02 84 of 94, T17 of 86, but they really lay out the foundation for this more global assessment of the basis to support the generalization that is associated with this kind of an amendment. And there it sets out a couple of considerations. Firstly, here we have a consideration of whether the extracted feature enables the object of the invention to be realized absent the other features of the embodiment. And in a similar sort of vein, but perhaps from a different perspective, does the claimed combination of features have a technical function which contributes to the solution of a recognizable problem? And so these decisions touch on clarity as well as scope of claim in terms of whether the generalization that you're making means that the essential features of the embodiment are preserved or not, and also whether the claimed combination of features is sufficient to produce the result that is sought in the application. And if that is the case, you know, you do still achieve that result, and there's all the essential features are preserved as a result of the amendment, then you've got a lot stronger arguments that your amendment is justified and that there's no unallowable intermediate generalization. Okay, so this next case is interesting for a couple of reasons. So T500 of 11. And this is interesting for a couple of reasons, namely one of them being that it establishes an example of where there wasn't deemed to be this inextricable link between features, specifically in relation to a working example. But it also approaches things from a slightly different perspective. So in this case, a feature was extracted from a working example, and that feature was a specific concentration of 550 ppm here of chromium. This invention relates to a process for preparing trichlorosilane using silicon and HCl gas, and it's the presence of chromium that's quite important to that. And in order to extract that particular concentration without being seen as an unallowable intermediate generalization, it was necessary to establish that that concentration was not critical for achieving the technical effect. And the applicant in this case was able to do that by showing that it was very much in general that the addition of chromium was important rather than the specific concentration. And it's worth just me mentioning that the reason for this particular amendment was to get round more of an accidental anticipation, really. And so the applicant was relying on this amendment to ensure novelty of a document rather than inventive step as such. And so this approaches things from a slightly different angle in that it was necessary to show that the extracted feature wasn't critical for achieving the technical effect, whereas we'll see in other cases the opposite can be true, and that in order to extract the feature, it can be seen to be necessary to show that that feature in the claim combination is important for solving the problem underlying the invention. So here it was seen that there was no reciprocal relationship between this extracted feature of this very specific concentration of 550 ppm and the other features of the example, which included such process features as pressure and temperature and the contact time and the like. And it may have been that the sort of difference here between product features in the terms of this particular concentration and process features made it easier for the board to conclude that there wasn't this sort of functional or structural relationship there, and that in the terms of a potential inextricable link, the conclusion was that if there was an inextricable link there, you would only be able to achieve the aim of the invention by using those very specific combination of features of the example. And there was plenty of evidence in the specification as filed that that wasn't true. And so the conclusion here was that there was no inextricable link, and as a result, there was no unallowable intermediate generalization, and that the feature could be extracted and applied to the wider context. Moving on then to our next case. This case is interesting because it encourages more, again, a global assessment of the specification when assessing support for the amendment or the intermediate generalization. But it also points to the relevance of commonality between distinct embodiments. So a consistent disclosure of the extracted element across distinct embodiments can be useful in justifying a generalization. But also this case also sets out where the remaining features of the embodiment can be seen to be incidental, and so more easily divorced from this feature that's extracted. And in this case, it's set out that based on the totality of the disclosure, which is read contextually, that it would be clear to the skilled person that the particular feature extracted in this case was incidental. And this case related in particular to a cleaning brush that had a particular holding arrangement. And this holding arrangement was important for achieving the technical effect of the invention, and was also common to a number of different embodiments. And so it was seen to be relevant to the board there that you had this repetition of that feature across different embodiments, and that particular holding configuration solved the problem, whilst other features relevant to the nature of the brush were more incidental to achieving that effect, and so could be more easily divorced from the extracted feature. And on that basis, there was deemed to be an allowable intermediate generalization. Okay, just moving on to another example. And here, this again sheds more light on the consideration of when features can be discounted from an embodiment, and that aren't seen to be inextricably linked, so that a intermediate generalization would be unallowable. So here, when it's clear that those features don't contribute to the solution of the problem underlying the invention, then they can be disregarded as being unnecessary to the definition of the invention, and therefore not necessarily to be recited in the claim. And this case is also interesting in as much that it advocates an assessment of the subjective technical problem, which is recognizable in the specification, and an interpretation of that problem, and then an assessment of whether features of that embodiment would be critical or would contribute to the solution of the problem. So in this case, there was a battery which had particular features of a housing, a cover, a container, and some flanges. But the problem that was considered recognizable on the basis of the disclosure as a whole was obviating the coupling of terminals to the battery and improving the battery lifetime. And when the problem was set in that light, certain other features of the embodiment at issue, including the cylindrical and thin-walled nature of the container and the circular surface of the cover here that's underlined, as well as as the length relationship between the first and second flanges, the board concluded that those were unnecessary for solving that problem, and so could be discounted, and therefore extraction of the particular feature defining the battery, which was relevant to the solution of the problem, could be isolated and applied to the more general context in the claim. Here again is another example of when features in an embodiment can be justifiably discounted. And this provides an example of where those features are technically disassociable. And it's interesting in this case that that the board saw these additional features from the embodiment that weren't extracted as being optional. So there was perhaps some statements in the specification that made it clear that those features were optional or replaceable with technically equivalent means. And so this case is interesting in as much as it advocates more of a wider assessment of the additional features of the embodiment to decide on their relevance to the solution of the technical problem and the contribution to the technical effect. And so it is also, again, useful for considering whether or not there are arguments at hand in your own particular circumstances that can be deployed. Moving on to a slightly different approach, which is developed more recently, which is T1906 of 11. And this, I would say, advocates an even broader assessment of the technical teachings that are derivable from the specification as filed when assessing intermediate generalization, which is on the one hand encouraging, but on the other hand more ambiguous in terms of when it would be seen to clearly apply to one's case. So here, the relevant question was seen as whether the skilled person is confronted with any additional technically relevant information in terms of the claim that results from the amendment versus the original disclosure. And if there is no new technical information that is derivable, then the amendment must be in line with and consistent with Article 1232, and there's no added matter or extension of subject matter. This approach also seems to have been followed more recently in T1617 of 19, and I only really highlight here the wording that has been used by the board as being relevant to that. And it's clear here that there's reference to the skilled person not being presented with any new technical information. The board go on to discuss the fact that certain features here, these shoulders and planar portions, have no functional relationship between each other, and so on that basis aren't inextricably linked, and so there is no unallowable intermediate generalization. But it's interesting that I've also referred to this technical information that would be derivable in reaching that decision, and so perhaps suggests a movement toward this kind of an assessment of intermediate generalizations in the future. Now that we've gone through some of the case law developments, we can compile somewhat of an argument checklist or a set of considerations that we can apply when faced with an intermediate generalization objection. And depending on the nature of that objection and the circumstances around our particular amendment, then these are good to consult to see whether they give us some opportunities in terms of arguments. So the first being then whether the extracted feature achieves the aim of the invention absent the other features of the embodiment. Second then, whether the extracted features, as we've discussed, are incidental to the functioning of the embodiment or the solution of the problem. And along a similar line, whether those features are technically disassociable. Are there any statements in the specification as filed which make it clear that those other features of the embodiment are optional or replaceable with technically equivalent means to help justify those features being divorced from the feature that we're extracting. And now, moving toward this new approach, whether there's any new technical information that the skilled person is confronted with on being faced with the new claim as a result of the amendment in comparison to the original disclosure. And finally, whether there are multiple embodiments that have that extracted feature in common, which also might help justify this kind of generalization. So armed with this checklist, I'm now going to hand over to my colleague Posy, who's going to run through something of an example scenario, which hopefully will give some guidance from a more practical perspective.
Thanks, Mike. So in our example scenario, our claim relates to a fire-resistant composite laminate. And the fire-resistant composite laminate comprises a matrix material, which is reinforced with fiberglass fibers. And the claim has been amended to say that the matrix material comprises, so it used to say a polymer, and that's been replaced with a list of specific polymers that can be used in that matrix material. Basis for this amendment is from paragraph 47. And if you look at paragraph 47, that refers to the fiberglass fibers that are already mentioned in the claim. And it refers to the polymer list, the list of polymers that can be in the matrix material that has been introduced into the claim. But it also has this feature that the fiberglass fibers are unidirectionally oriented. And that feature hasn't been introduced into the claim. So you are, intermediate generalization is extracting the list of preferred polymers while leaving the feature of unidirectional orientation, while not extracting that feature, leaving that feature behind. And the passage which provides basis also refers to a technical effect. So it says, a matrix material comprising at least one of these thermoplastic polymers has been found to be particularly effective in imparting fire resistance to the laminates. So our notional examiner has raised an objection, and they say that new claim 1 does not include the feature that the fiberglass fibers are unidirectionally oriented. And this feature is inextricably linked in the specification with the feature that the matrix material comprises at least one of the preferred polymer compounds. The amendment to claim 1 therefore gives rise to an unallowable intermediate generalization. So faced with this objection, we can then go back to Mike's checklist and have a look about at whether any of the approaches that he outlined might help here. So what could I try arguing? The first approach, if we apply it to this scenario, would give the question, does the use of the specific polymer matrix materials achieve the aim of the invention absent unidirectionally oriented reinforcing fibers? And so here you could quite legitimately argue that fire resistance, which is mentioned at the start of the claim and is mentioned in the in paragraph 47, the passage that you've relied on for basis, you could say fire resistance is actually achieved by the polymeric materials, and it's not really got anything to do with the orientation of the fibers, which relate to the robustness of the laminate. So even if you don't put in the unidirectional orientation, you're still achieving the aim of the invention. And the next approach is quite similar. So when you apply it to this scenario, the question would be, are unidirectionally oriented reinforcing fibers incidental to the functioning of the embodiment or the solution of the problem? And again, you could say, well, the orientation of the fibers isn't really of any significance to the performance of the laminate as a fire-resistant composite. So in our hypothetical scenario, these approaches are quite good ones to take because the argument is quite simple and it makes technical sense. So the next slide goes through the other arguments that we've put in the checklist, and it shows how they perhaps don't work as well in this scenario. So the third argument applied to a hypothetical situation would give the question, are fibers that are unidirectionally oriented technically dissociable, for example, optional or replaceable with technically equivalent means? And here you could argue that the fiberglass fibers could be oriented differently, but whether they would still have the same reinforcing effect is doubtful. It seems technically sensible that orienting them in the same direction helps with that reinforcing effect. So this argument is, this sort of line of argument is perhaps a bit weaker in this case, unless you have other supporting statements in the description which tell you things like, discuss different orientations of the fibers or different reinforcing means that could be used. And the next questions are similar. So, is the skilled person presented with new technical information? Are the specific polymer matrix materials common to other embodiments? And again, you're really relying on other passages in the specification that mention that the matrix materials don't necessarily have to be used with unidirectionally oriented fibers. So it might be another embodiment where you have the one or more of the preferred polymers and you don't have unidirectionally oriented fibers. So you can argue there that there's a sort of good reason for generalizing. So the arguments on this page would actually work much better with a scenario where you do have a spec. You could have a very claim which had something like a fastening means in it, and you have an embodiment where there's a screw and you're plucking a different feature, but you're not amending your claim to say that your fastening means is a screw. And if your description had other embodiments and they had a pin as a fastening means and something else, then these type of arguments would work quite well in that sort of scenario. So a word of caution about this checklist. The examining divisions are often, not always, but can be persuaded with these type of arguments. But that doesn't mean that you'll be okay in opposition proceedings. So just because you got away with the amendment during prosecution doesn't mean you won't come unstuck post-grant. So when you do make this type of amendment, it's always important to just think, okay, if I was forced to put in other features from this embodiment, would that be okay? And so you need to think about things like, obviously the scope is the big one. Is that still okay from a commercial perspective? But there are other considerations like, well, would the other features in this embodiment that I might have to put into the claim down the line, would they be allowed? So are they clear? Do they make sense? Will they give rise to other formal objections that preclude me from introducing them into the claim and solving this potential added matter problem? So it's just good to bear in mind that just because you've had your first victory with the examining division doesn't mean that you're home and dry. Finally, some drafting tips. The first one is just something that is super simple to do and we still see not done sometimes. So make your dependent claims multiply dependent. If you don't want to do that, then just copy and paste your claims to the back of your specification and renumber them as clauses or embodiments and add multiple dependencies in there. And that just makes it so much easier to point to features which would be isolated in different combinations. And it just makes it much, much easier in Europe for making amendments. And so copied an example here, and you can see embodiment 5 refers back to the compound of Formula 1 generally, or of embodiments 2 or 3. And this is just, you don't even really need to think about this. This is just a very simple thing that you can do that doesn't take much time and can make your life much easier down the line. And these further tips are not quite so simple, but still fairly easy to think about. So make clear in the description where features are optional or where features may be replaced by technically equivalent means. It's also quite useful with the figures to have really detailed figures which explain the invention in detail, but also generalized versions of those figures where you're really stripping the invention back to the bare essentials, perhaps defined a bit functionally, just to show that you can sort of interchange. Yeah, well, like a fixing means, you could use different fixing means in the different embodiments, and you're not just stuck with the one that's described in the embodiment that you're relying on for basis. And similarly, this is going back to the concept of commonality that Mike spoke about, and that's where the fact that your feature that you're extracting is in a number of different embodiments shows that that feature isn't necessarily inextricably linked to the other features of any particular embodiment. And finally, describe the aim of the invention in general terms, so you can rely on this sort of general purpose and whether the invention is achieving that general purpose. So in our hypothetical example, we had fire resistance, which we could rely on because that doesn't really have too much to do with the reinforcing fibers. And where possible, when you are describing advantages, describe those in connection with individual features rather than a group of features. So in our hypothetical example, one of the issues was that at the end of the sentence for basis, the technical advantage was at the end of a sentence which actually referred to polymer materials and the orientation of the reinforcing fibers. And it would have been much better if you just had two sentences, one about the orientation of the reinforcing fibers, and then one about the polymers and the benefits of the polymers. On to Q&A. So I'm going to try and pull up questions. Okay, so one of them is very easy. A copy of the slide presentation be available to attendees. I think that's fine. I think Saba can do that. So how does the gold standard for basis at the EPO fit with this issue? Mike, do you want to?
I would say that so the gold standard, of course, sets out that that the basis should be directly and unambiguously derivable from the specification from a skilled person operating with his common general knowledge. And of course, that's the sort of framework within which basis is assessed now at the EPO. But I don't think there's anything necessarily inconsistent with the case law that applies to intermediate generalization. And in fact, the way it seems to be progressing with this more recent case law, where we have this more general approach to the assessment of the technical information that's derivable from the specification as filed, and a comparison between that and the content of the claim containing the extracted feature, it would seem that that movement is actually aligning more closely with this with the requirements of the gold standard. It perhaps means that there's less of a sort of guideline as to what situation would give rise to added matter and where it would not, but clearly a wider assessment of the technical information that would be derivable from the specification seems to be more of a sensible one rather than a very lazy assessment of the literal content of a paragraph without any real regard to, what the invention is. So I think that certainly the case law still is consistent with that gold standard.
I think that that sort of answers another question that we've had, which says that some of the case law, as you mentioned, Mike, is fairly old, and are there any recent trends in particular? And I think that's definitely a trend across added matter objections of all types really that the EPO is kind of coming back to again and again, their gold standard, and perhaps finding tests that have been quite helpful really for us as attorneys, but perhaps finding some of the older tests, not paying as much attention to them and just focusing on whether something is directly and unambiguously derivable. So someone has asked a question about how might the EPO view disclosures that only have optional features, i.e. no essential features?
So I guess this can be more common with US style drafting, where there's often a reluctance to ascribe technical effects to particular features. And I think that can be quite difficult to reconcile for at least some of these types of arguments that we've looked at today. But I think really in that particular case, where you can't really, or the solution to a problem recognizable in the specification is more difficult to identify. I think that really the answer to that is when you are drafting, those applications and don't want to put that level of information in your disclosure for whatever reason, perhaps for reasons of that are more relevant to US practice, that you do though nevertheless have these interdependent embodiments at least included in your specification to give you that more literal basis for amendments. And I guess if you, if there are a lot of optional features in there, but nevertheless there are working examples where you have combinations disclosed, and perhaps it's perhaps not even said in explicit terms, but it would be clear that a technical effect derives from that particular combination, then that might be also useful for you to be able to point to without necessarily having the explicit commentary around the effect of a particular combination. So I think in general it's likely to be a balancing act between optimizing your arguments based on the particular situation that you're in.
And I would say also with when you have lots of optional features, it's still for intermediate generalizations good if you can have those optional features in an isolated form. So rather than lumping a whole load of optional, sort of an optional feature that has 3 sub-features, if you can have each of those sub-features sort of referred to in an isolated way for the purposes of intermediate generalizations. So probably got time for a few more questions. So do the national courts in Europe adopt a similar approach?
So traditionally, the UK IPO has followed the European line, but is perhaps less rigid in its assessment of basis, and is possibly a little less strict. But actually, there's been a recent case in the UK IPO, which is Philip Morris v. BAT, where there was it was found that there was an intermediate generalization in that particular case, and it was considered relevant, or there was a nod to the requirements set out in the guidelines, for instance, where there was established to be this inextricable link between certain features that were included in the granted claims in that case and other features of the embodiment from which it was extracted. So although historically the UK IPO, for instance, has been far less strict in terms of its assessment of basis, particularly in regard to intermediate generalization, there's certainly evidence that that they're also willing to follow a stricter approach, more recently. Whether or not this is a bit of an outlier, I guess it remains to be seen. But certainly that's an example of where they've actually followed what the EPO have done quite closely.
Yeah, I'd say that perhaps UK patent examiners will probably still be a bit more lenient, might take a bit of time for the stricter approach to trickle down from the courts, but I mean, plenty of people just never really do direct prosecution at the UK IPO. So, okay, so can features be isolated from drawings?
So yeah, this is an interesting one. I guess that they can, and it will always depend on the particular situation again. Often it can be helpful if there is commentary on the figures that you can point to in the specification itself. It can be quite difficult to extract features that are evident in a figure, for instance, but not discussed in explicit terms in the specification itself as filed. And so having some sort of written support for a feature is always going to be useful. I guess it highlights again this commonality issue, that if there is a feature that's common to all the figures, and perhaps not so well expressed in terms of written disclosure in the specification, then that might be an extra justification for using that as a feature from which you generalize. But I guess the short answer is that yes, those features can be isolated, but often it can be difficult to, I guess, disassociate a feature taken from a drawing from the other features of that drawing. So I think you mentioned, didn't you, about including more general figures in your specification, or sort of more schematic ones, and so that, you know, highlights where that can be quite critical to the allowability of that kind of an amendment.
So somebody has asked about examples of the embodiment language to put in at the end of the spec. I think we included that in the presentation, but please just email us if you have any more questions on that. So I think we probably have time for maybe one or two more questions. So Michael mentioned case law, where the EPO assessed whether the extracted feature and the features left behind in the claim were important for realizing the object of the invention. Is this the object of the invention overall? So I guess is that the inventive concept as a whole, or the advantage associated with the particular embodiment? So good question.
Yeah, so I guess it's a difficult one. There isn't absolute clarity on that, but I would have said that it's probably more the problem that is solved by the embodiment, because I think if there's reasons then to conclude that that particular features of that embodiment are important for realizing the effect there, and you can make an assessment on that sort of more confined assessment of those features that are non-essential to achieving that, then it helps in your justification. But you know, often it is the case that you could almost identify multiple problems that your invention purports to solve at various levels of generality within your own specification, and so that could be set out quite broadly initially. But I guess really you want to be flexible in some ways, and what suits your arguments most conveniently, really, because it might be the case that you don't want to import a certain feature of an embodiment for whatever reason, and it might be a better argument to make based on a problem that is a bit broader on the basis of certain passages of your specification, rather than what's, you know, more specifically associated with that embodiment, for instance. So I guess in some ways it's a case of aligning your arguments with what you feel is likely to be most persuasive as well.
Yeah, I would say that if you have a definite technical effect sort of ascribed to the embodiment that you're extracting a feature from, you would possibly struggle to ignore that.
Yeah.
If you're running this sort of almost inventive, it's not really inventive step, but sort of inventive concept type argument. Saba, do we have time for one more, or should we?
It's probably the best time to start wrapping up, actually.
Fine.
But thank you, and great to see so many questions come through. Just like to highlight that if you had any further questions about this topic, then please feel free to email Posy and Mike. Their email addresses are there. And yes, just to reiterate what Posy said before, I will be sharing the presentation slides and a recording of the session post this webinar. And really just to say, lastly, to say thank you to everyone who joined us, and we hope to see you at a future webinar. So thank you and take care.